pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Again, good morning. The first thing on our agenda is the consent agenda. Approving minutes of September 3rd, approving payroll, approving vouchers, approve and sign monthly earnings and collections from the clerk of district court, and the sheriff, approve and sign the lease renewal for Thomas Boyd, approve and allow chair to sign this amendment to the grant between the state of Wyoming and the Park County Library System, clarify remaining ARPA appropriations, and approve and allow chair to sign the Park County 25-26 Community Prevention Grant. Commissioners?
Madam Chair, I move to approve the consent agenda as presented.
Second.
Been moved and seconded to approve the consent agenda as listed. Is there any discussion on the motion? Any discussion? Hearing none, all those in favor?
Aye.
Opposed? Motion passes. The next thing on our agenda is a public hearing. Staff should be in any minute. Public hearings to start at 9:35, and there they are. Morning, Jen. I think we can go ahead and get going.
Get started? Okay, all right. Thank you.
Please use the microphone.
Yes. Okay, so yes, this is the amended plat of Kramer MS-44 for lot 5 of the no build zone. As you mentioned, it's a public hearing. You've been provided the staff report and packet and supporting documentation, and that's also on file in the Planning and Zoning Department and a matter of public record. I'll summarize the findings for you. Dusty Gravatt. Don't want to slaughter it. Gravatt submitted an amended plat application requesting approval of the amended plat of Kramer MS-44 lot 5 no build zone to partially vacate and alter the no build zone described and shown on the final plat of Kramer MS-44 as the south 615 feet of lot 5. The proposed alteration to the no build zone is the north 50 feet of the no build zone be restricted to development of structures no taller than 13 feet. And then a 415 feet of no build zone remaining in the middle. And lastly, removal of the south 150 feet of the no build zone. To give you a little history, on February 16th, 2021, the resolution number 2021-08 by the Board of County Commissioners approved the Kramer MS-44 final plat. This established the no build zone and consisted of 5 lots. In May of 2021, lot 1 and lot 4 were sold by Joanne Kramer, the developer. And on August 19th, 2021, an unrecorded inspection contingency notice by and between Dusty and Jessica Gravatt as buyer and Joanne Kramer seller was provided, and it states, 1, the seller agrees to allow buyer at buyer's expense to remove 50 feet of the north side of the no build zone with a height restriction of no more than 13 feet tall. Seller also agrees to allow buyer at buyer's expense to remove 150 feet of the no build zone on the south portion of the no build zone from the south property line north 150 feet, as long as seller is the owner of lots in the Kramer MS-44 subdivision. Seller will sign in favor of this change. And then another unrecorded document was provided. This was signed between August 20th and August 27th, 2021 by the owners of lot 1 and lot 4 and the developer as owner of lots 2, 3, and 5. And it states the 50 feet of the north portion of the no build zone to be changed to a height restriction of no more than 13 feet tall, 150 feet of the south portion of the no build zone to be removed, 415 feet of the no build zone to remain a no build zone. On August 27th, 2021, lot 5 of the Kramer MS-44 was conveyed to Dusty and Jessica Gravatt from the developer. In October of 2021, Lot 2 and Lot 3 of the subdivision were sold by the developer. Moving forward, the subdivision is located approximately 100 or 1.5 miles north of the city of Powell, east of State Highway 295 on the south side of Lane 6. Lot 5 is partially developed with an existing permitted storage shed and a shop building that is under construction. The property is relatively flat. Residential lands border the north and west boundary. Ag lands are adjacent to the east boundary, and residential vacant lands lie to the south of Lot 5. The subdivision is located within the general rural Powell zoning district, and the lot size will remain unchanged. Partial vacation of a recorded plat is permitted for the purpose of revising building envelopes or notes shown on the final plat. Therefore, an amended plat is required to alter this no-build zone. The planning director determined a public hearing is necessary due to potential impacts to other lot owners in the subdivision because the no-build zone may benefit and impact the view shed of other lots or properties. Public notice requirements have been met, agency referral requirements have been met and responded as follows. The Park County Treasurer stated the 2023 taxes are paid. The first half of the 2024 property taxes is due on November 10th, and the second half on May 10th. Wyoming Game and Fish have no comments. Park County Public Works have no comments. Shoshone Irrigation District confirmed they have no requirements for the proposed amended plat. Park County Weed and Pest has not provided a response. The subdivision is located in an ag overlay district, and the applicant is required to comply with any requirements of Park County Weed and Pest and maintain irrigation facilities and ditches. A note has been placed on the plat regarding the Wyoming Right to Farm and Ranch Act. The owners of, regarding public comments, the owners of Lot 3 of Kramer MS 44 provided a written comment in opposition of the proposed amended plat. In summary, their comments indicated that property owners purchased lots in the subdivision based on the existing rules created by the seller to protect the value and integrity of the property. Approval of the amendment sets a precedent and could be harmful to property values and harmful to the neighborhood. In a letter dated September 13th, Colin Simpson, attorney on behalf of the adjacent landowner to the east of Lot 5, stated their opposition to the amended plat. In summary, they purchased the parcel in December of 2021, and it was their understanding the no-build zone was in place and would remain in place to protect their views of Heart Mountain. Mr. Simpson also stated on September 1st, 21, Lot 5 of the Kramer MS 44 was sold to Gravatt. The warranty deed from Joanne Kramer to the Gravatt states that it is subject to all patents, easements, right-of-way, reservations, zoning restrictions, covenants, and other matter of public record or otherwise established, all assessments and subsequently assessed taxes. He also stated the Gravatts cannot rely on an unrecorded document purporting to amend a plat as the parcel vacation process requires an amended plat. And such an unrecorded document does not give public record notice that the Highlands, his client, or a title company could have discovered upon inspection of the public records. The Highlands were bona fide purchasers for value of the Kramer parcel without any notice of an unrecorded and unknown purported plat amendment. The plat review committee reviewed the amended plat, and the owners of each lot shall sign the amended plat, thereby agreeing to the proposed amendments. We have a few recommended conditions should you approve the amended plat, and I'll read those for you. Number 1, the notarized signatures of all lot owners within Kramer MS 44 shall be required on the amended plat prior to the chairman of the board signing and recording. And the applicant shall otherwise comply with standards in the Park County Development Regulations and the minimum subdivision requirements as set forth in Wyoming Statute 18-5-306.
Thank you.
Have any questions?
Any questions at this time for staff? Seeing none, we'll open it to the public for comments. If you do have comments, if you would please come up front to the microphone, need to identify yourself for the record. And please use the microphone as these meetings are broadcast and recorded. Appreciate it. So is there someone who would like to speak? Mr. Simpson?
Thank you, Madam Chairman, members of the commission.
Jimmy? Ladies and gentlemen, lady and gentlemen, Wyoming statute 34-1-121 is titled Recorded Instruments as Notice to Subsequent Purchasers. And it says in subsection A, each and every deed, mortgage, instrument, or conveyance touching any interest in lands made and recorded according to the provisions of this chapter shall be notice to and take precedence of any subsequent purchaser or purchasers from the time of the delivery of any instrument at the office of the county clerk for record. So if the document's not recorded, how do you know about it? And that's why we have that statute, I think that goes back to 1892. So the Highlands were not aware of any amendment to a plat that had been signed by anyone until after they purchased their property from Joanne Kramer. And that's why that's called the Kramer property rather than the Kramer MS 44. So that was Joanne Kramer's house that looked directly to Hart Mountain. And that's why she put the deed restriction on lot 5 of the Kramer subdivision. So that view would be unimpaired. We all appreciate great views in Park County and Hart Mountain. And so did the Highlands when they bought the property, believing and of record showing that no build zone was there. It wasn't until we saw the staff report that it was indicated that there was some other unrecorded document, which was the conditional contract that Mr. Gravatt apparently had with someone to purchase lot 5. But those documents, the unrecorded documents, can't take precedence over the recorded documents. And Mr. Gravatt and Mrs. Gravatt, sorry, took the property subject to the warranty deed that had the clear language that it was subject to those things that restrictions of record. And the no build zone is a restriction of record, clearly. So while I'm sure the Gravatts feel that they've been wronged in some manner, that is not anything that I think you're dealing with today. You're dealing with the question of whether or not it should be amended to impair not only my clients who are next to the subdivision, but also other members of the subdivision who I think have objected, the owners of lot 3, and may object further today. But we provided some photos showing what we believed would be the impact of that 100-foot, which was what we believed it was at that time. And then I think they filed an amendment to the application to make it 50 feet, but still, you can see Hart Mountain in these photos. And so from the right side of the photos, that 100-foot would impair that whole view. And especially if it's anything of any height, the view is gone, which is what the Highlands purchased the lot for, believing that they would be protected into the future by that no build zone. So, and you can see their views from various portions of their property and their home. And they purchased the property, I believe, December 10th of 2021, which was in this year where all this was happening. It just happened to be the end of the year. So when they purchased, they were what in legal terms would be bona fide purchasers for value without notice of some other amendment to the plat floating around out there or a ghost document. It would, I think it's clear that the Highlands have the right to rely on those documents, and the Gravatts may have issues with someone other than planning and zoning and the commissioners about use of the property that they purchased. So we would ask, unfortunately, these these disputes amongst new neighbors are very difficult and ones we would like to avoid, but the Highlands purchased for reasons that I've expressed, and we would appreciate it if you would deny the application. And I'd be happy to answer any questions you might have.
Commissioner?
Sure. 34-1-121, I believe. 34-1-121. Recorded instrument as notice to subsequent purchasers. And then it goes on to talk about other deeds or recorded instruments issued by the US or the state of Wyoming. Thank you.
Any other questions? Thank you, Mr. Simpson.
Thank you very much.
Anyone else that would like to make any comments today? Yes, sir. Yes.
Hi, so I'm Dusty Ravat. I basically, I bought this property with the understanding with this amendment. Basically, I'm not asking to build a big shelter or building to obstruct anybody's views. My intent is to have horse covers, shelters for my horses, is all this is over. And it's basically over 30 feet. Attaching to the side of the shop building that I've just recently built. I'm asking that I could put this shelter attached to the side of this shop and then at that point and go out 30, it would be 30 feet into the no build zone is what it would be. And at the lowest point of the shelter, it'd actually be 9'6". So it's not 13 foot like it's made out to be. That's the exact structure that I'm asking to do. This document was not a floating document like whoever. This was with Joanne Kramer. When I bought this property, I was going to turn away from the property until she made this amendment, and she actually came up with these dimensions. The 13-foot high I asked for, and then she was the one that gave me the 50 feet from to the south of that no build zone. And then she also was the one that that pulled back on the 150 feet of the very south. She was the one that came up with this, and the reason she came up with these numbers is because she felt that her view was still adequate enough that she would be happy with. She agreed. She said from the beginning, before doing the subdivision, that she was not going to sell anything because she did not want to lose that view, which I am totally in understanding about. And she is the one that came up with those dimensions on my property. With that being said, I did call Dave Highland and ask him and Brittany to come over, and so that I could go over with them what I would like to do with my property. And they did come over, and they expressed to me that when they first got the letter and it said 100 feet, that they were very excited and very disappointed, and that they were not going to approve it. And I explained to them that I felt I could understand that, and that in fact that it was nothing of 100 feet, that I only wanted 30 feet from the side of that building, to be exact. And then the height. And I even said that I would volunteer to put a flag, like some flags and a stake in place, so that I could show the outline of the view that they might, think that obstructs them. And at that day, I felt when we shook hands and walked away that we were okay, and that they said that they would not approve 100 feet. And I assured them when this meeting come that they would hear that this is all I wanted. What the amended letter was given from Joanne is all I'm asking for. It's very unfortunate that it wasn't recorded properly. I don't know I don't know why and how this actually happened, but I guess I have to figure that out, but, this is all I'm asking for. I'm not wanting to build a big Taj Mahal or something, you know, this is very small in my, this is over horse stalls, not a big shelter or something.
Question?
Yeah, Mr. Grad, unfortunately, there's two things here that I'm weighing. One is the other folks bought their properties years ago with Miss Kramer saying there's a no build zone, and then to have her go and change it a little bit. I have a little bit of issue with that, but also you got to understand too, is you say this is all I want to do. If the no build zone goes away, but if you sell that on down the line, and this plat's been amended, the new people can come in there and build right to what it is. So I understand the neighbors' concerns, and again, unfortunately, it wasn't recorded, it didn't go through the public process, and I'm struggling with approving this.
Anything else?
And you see that the neighbors that were in place at that time, they did sign that amendment as well. You see that? Debbie Fitzpatrick signed it. They were all in agreement. They knew it as well. But I totally understand that the plot plan was not reflected.
Yeah.
So I don't know, do you have any advice on which direction I would go in the fact that it would have to be the realtors are responsible for the bait and switch?
I'm not a lawyer. There's one sitting there in the back of the room. I'm
Yeah.
definitely not gonna go there.
Yeah.
I don't. I can't really offer any advice along those lines.
Thank you. Is there anyone
We got a
else?
realtor in the room too. You can
Yeah.
chat with her.
Is there anyone else that would like to speak to this issue? Yes, please, if you come forward, we need to kind of keep moving. Or we'll have to. Change our time frame.
Okay, so I'm Debbie Fitzpatrick, as Dusty has pointed out. And yes, we did back in September of 21, we signed an amendment that we completely regret. And I'm speaking for my husband as well, who is a, my husband and I reside at 82 Lane 6. We live in Powell, we work in Powell, and we're part of the community. We moved here from Oregon. Oh, so sorry.
You need to.
We,
You need to.
Yes, thank you.
so we moved here specifically for getting out of Oregon because people are coming in and making changes. And it was ruining a beautiful location. So we moved to Powell, just for a little background. It's a rural community. I met Joanne Kramer. She was a wonderful lady, and she built that house, and she couldn't keep it up. She was going through a pretty hard time. My husband and I lived on our property before we started building, and so that place there was a lot of chaos. And when it was approached to us about making an amendment, she really was trying to sell property because she wanted to move. She couldn't take care of the place, wanted to move to Florida. Just she had a lot of health concerns. And so my husband and I did that for her, not knowing the impact that it made. It's hard to visualize what's going to go in until you actually know what they're thinking. And so we did it with regret. We are hopeful and prayerful that a 3-year-old document that is not notarized, that is not recorded, will be null and void. The Franks, which have submitted a letter with stating they do not agree with the amendment as well. They are new, so we were the first ones to actually build there. And without even asking us, they built their house to where it doesn't even affect our view. My mom lives on the side of ours. It doesn't affect her view either. The property all of the properties are placed so everyone can enjoy all the amenities and all of the views. And I think that's really important. We had a great view off to the, my direction should be correct, to the east of the Highlands, beautiful log house and the big house. Now Dusty has built a shop right there, and I'm thinking, you know, maybe we could have communicated. We're all good neighbors. We've had a few little squabbles back and forth. But we're all neighbors. My husband and I, we've been on everybody's property trying to help everybody because that's what neighbors do. And I think that's super important. I have to look at some notes because I get super nervous when I'm with them. So as stated in Frank's letter, there's freedom to allow everybody to have what they need and what they want to desire. So with that said, the Highlands purchased their home. They thought there was no build zone. They are tremendous contributors to our community. We all. The Gravats don't live here year round. They're here a few months out of the year. They don't live here. They don't work here. And I'm sorry, Bessie, I want to be a good neighbor. And so, their vehicles aren't licensed here. There's no contribution. And I feel bad. I'm sorry that it happened to them. I'm sorry that we signed the amendment. But there are ways that we can all get around it and we can all be neighbors. There really is. Just the bridge has to be mended. And do I think it's accomplishable? Absolutely. So with that said, I'm hopeful that you will stand by it, because if you give an inch, a mile is going to be taken. And there was precedent. It was put in place for a reason. I hope that's my hope. Okay. Thank you.
Questions? Okay, thank you.
Oh, I'm sorry. Don't any questions.
You're good, I think.
Okay.
Thank you. Anyone else that would like to speak to this issue?
Madam Chair, move to close public hearing.
Second.
Moved and seconded to close the public hearing. Any discussion on the motion? Hearing none, all those in favor?
Aye.
Anyone opposed? Motion passes. It's a pleasure of the board.
Madam Chair, I move that we deny the amended plat application.
Second.
Been moved and seconded to deny the application to amend the plat. Any further discussion on the motion? Hearing none, all those in favor?
Aye.
Aye.
Anyone opposed? Motion passes. Okay, thank you.
Almost back on track.
Yeah. Thank you, Ricky. The next thing on our agenda, Jenny Kramer, we have another public hearing. Rock River Estates, minor subdivision number 84, sketch plan review.
Thank you, Madam Chair. Yes, and the staff report and packet has been provided to you previously and is on record in our office for the public to view. In summary of the findings, David and Debbie Vardaman, on behalf of Jeremiah and Rachel Vardaman, submitted a minor subdivision application requesting approval to split a 1 acre lot for residential use from an existing 102.02 acre parcel, and will result in a 101.02 acre remainder parcel. The subdivision is classified as a minor subdivision and is within a GRP zoning district. The lot sizes are consistent with the GRP zoning district. The subdivision is located approximately 3.5 miles southeast of the city of Powell on the west side of County Road 5, north of County Lane 11.5, with an address of 1104 Road 5 in Powell. In April of this year, the Planning and Zoning Department issued permits to construct a residence and small wastewater system, which happens to be on this proposed lot. The remainder parcel is developed with a permitted residence, accessory structures, a septic system, and a water well. The majority of the remainder parcel is irrigated and productive cropland. The parcel is relatively flat. Neighboring land uses are residential, residential vacant, and ag with some exempt BOR lands nearby. A couple of small or simple subdivisions and a minor subdivision bound the property, and other small subdivisions are in close proximity. I'll also mention that the Harshman simple sub and the Gunner minor subdivision are part of this property's original tract of record, which is why this is considered a minor. The property is not located within 1 mile of a municipality, so that review is not required. Public notice requirements have been met and relevant agencies were notified as required and responded as follows. Park County Fire Protection District number 1 can provide fire suppression to the property. Park County School District number 1 will have bus stops at all exit points on County Road 5. TCT may be able to provide service to this location depending on line of sight to one of their towers. Powell Clark's Fork Conservation District identified 2 soil types on the property. The primary soil type is rated not limited, and the secondary soil type is rated very limited regarding dwellings with or without basements and small commercial buildings due to flooding and depth to saturated zone. Both soil types are rated very limited regarding septic tank absorption fields due to flooding, depth to saturated zone, seepage, and filtering capacity. The soil types are not considered prime farmland. Wyoming Game and Fish have no big game concerns. MDU has natural gas service available. Within the proposed access and utility easement that can serve Lot 1, service line installations cannot be initiated until a structure is erected that will use the natural gas. DEQ provided agency contacts and information for permitting associated with various construction activities. Park County Treasurer confirmed property taxes are paid in full. Garland Light and Power has the capacity to serve, and power service is adjacent to the proposed lot. Park County Weed and Pest is not requiring a long-term noxious weed management plan. Elk Level Water Users Association confirmed that they are in their district and they do not require a water distribution plan. Park County Public Works stated that legal access is proposed by a 60-foot access and utility easement to serve Lot 1 and the remainder parcel, in addition to a proposed 30-foot access and utility easement to serve the proposed lot. Rights of way for the proposed development are considered adequate. County Road 5 is a local access road and has a crushed gravel surface. A right-of-way permit will be required to construct any new access points or improve any existing access points to the county road system. No new roads are proposed. Any crossings of Elk Level Irrigation District facilities or Willwood Irrigation District facilities will require approval from said district. And addressing of the proposed development will be from Park County Road 5. They did not have any concerns with drainage and erosion control. USPS can provide mail service. No public comments have been received. A title report was received dated July 9th. A shared access and driveway is proposed across the remainder parcel. The applicant has stated maintenance will be shared 50-50 between the owner of Lot 1 and the remainder parcel, who will share use of the driveway. Solid waste disposal services are available. A high water table exists on the property. However, no other hazardous features are known to exist. A percolation test was completed on proposed Lot 1. The perk rate was 13 minutes per inch. A groundwater exploration cut was made to a depth of approximately 9'6" on the lot as well, and groundwater was discovered at 8 feet below the surface. Wastewater requirements have been met. However, since the groundwater cut was conducted during the off-season for irrigation and still evidenced high groundwater, the applicant shall place a note on the plat regarding that. Domestic water will be provided by individual on-site wells. And the applicant provided water quality results of water samples taken from a well on the remainder parcel, and they indicate the water meets EPA safe drinking water standards. Ag impacts have been addressed, as well as the impacts of surrounding ag activities, with the exception of addressing pests or litter and the confinement of pets. No stream or river is within or adjacent to the proposed subdivision. Utility requirements have been met. The applicant will be required to state how driveway maintenance responsibility will be shared on the final plat and disclosure statement, or provide a Driveway maintenance agreement to be recorded with the final plat. It appears that livestock can be legally run at large on lands adjacent to the proposed subdivision. So the subdivision is subject to Wyoming statute 18-5-319. Subdivision is within an ag overlay district, and a note regarding the Wyoming Right to Farm and Ranch Act of 1991 will be placed on the final plat. The Planning and Zoning Commission recommended approval of the sketch plan. No open spaces, natural areas, schools, or parks are proposed or required, and approval standard requirements pertaining to sketch plan review have been met. Planning staff recommends approval of the sketch plan of River Rock Estates MS-84 with the following conditions that I'll read for you. Number one, the applicant shall provide all easements as requested by applicable utilities and special districts. Irrigation districts or public agencies providing services, the width of any utility easement shall be sufficient to allow adequate maintenance of the system, but in no case shall such utility easement be less than 20 feet in width. Easements must be identified on the final plat. Number two, the applicant shall place the following note on the final plat: high groundwater may be present and engineered systems may be required. Number three, prior to final plat review by the Board of County Commissioners, the applicant shall address shared maintenance of the driveway in the notarized disclosure statement and do one of the following. One, state how driveway maintenance responsibility will be shared on the final plat and disclosure statement, or two, provide a driveway maintenance agreement to be recorded with the final plat. Number four, prior to final plat review by the Board of County Commissioners, the applicant shall provide evidence of one, an existing legal perimeter fence as prescribed by Wyoming statute 11-28-102. Two, written consent from all adjacent landowners, a perimeter fence is not necessary. Or three, plans to construct a perimeter fence is required by statute and in accordance with Wyoming statute 18-5-306, A13. Number five, prior to final plat review by the Board of County Commissioners, the applicant shall submit an appropriate subdivision improvements agreement, if applicable, addressing all applicable required improvements, utilities or fencing for review by staff and approval of the county attorney and the board. Number six, prior to final plat review by the Board of County Commissioners, the applicant shall place the following note on the final plat: any proposed water wells on these subdivision lots shall be permitted by the Wyoming State Engineer's Office prior to installation. Number seven, prior to final plat review by the Board of County Commissioners, the applicant shall place a notice of the Wyoming Right to Farm and Ranch Act of 1991 on the plat. And number eight, the applicant shall otherwise comply with standards and the Park County Development Regulations in the minimum subdivision requirements as set forth in Wyoming statute 18-5-306. Thank you.
Any questions for staff at this time? Commissioner?
Just a comment on condition 5, again, we need to change the language. Approval of the county attorney.
Thank you.
Approval form.
Yes. I don't know why I get into all of them.
Hit me once.
Okay, this is a public hearing. So again, I would ask that anyone that would like to come forward to speak on this issue, please do so. I would ask you to identify yourself and use the mic. Is there anyone that would like to speak to this project?
Madam Chair, Board, Nick Hummel with Engineering Associates on behalf of the owner and applicant. Believe everything looks great on the conditions. If you have any questions, we're here to answer.
Any questions for the design engineers? Okay. Thank you. Anything else? Anyone else would like to say, comment?
Madam Chair, I move we close the public hearing.
Second.
Been moved and seconded to close the public hearing. Further discussion on the motion? Any further discussion? Hearing none, all those in favor?
Aye.
Anyone opposed?
Madam Chair, I move we approve the River Rock Estates MS-84 sketch plan review with staff recommendations and the change to condition 5. Second.
A motion to approve as listed with the change on condition 5 and including staff recommendations. Any further discussion on the motion? Hearing none, all those in favor?
Aye.
Opposed? Motion passes. Okay. Thank you. Thanks. Okay. Hopefully Brian Edwards is out there.
Brian Edwards is in here,
He's in here now. Okay,
just like that.
That's government.
you're up here. Like my note. Okay, the next thing on our agenda is consider the addendum to the CMAR agreement between Park County and Roadhouse Construction. Consider the guaranteed maximum price for the Powell Library project.
Like,
The microphone. Thank you.
I know that's needed. But thanks, Madam Chair. As everybody knows, our Powell Library project is underway. The demolition's all complete, working on, the backfill and the compaction to get the basement filled in, and that's pretty much done. So they're working on a few other things, but anyway, things are going well, and we're at the point, as you know, there's some funding deadlines and requirements with our ARPA dollars that certain things have to be in place by October 1st. So that's the main reason we're here today, is that we've got a contract with Roadhouse Construction for a construction manager at risk. And then so the second part of that is getting an amendment for that guaranteed maximum price. Honestly, they're going to be down to the wire like the last week or two in getting that amendment in place and having all the other documentation that we need to provide to the state library. And everybody's in the same boat. Same thing with our septic lagoon project. But what we'd like to do today is request with everything that's been approved previously. As you recall, get this number right. Our funding that we've got from Wyoming State Libraries is right under 8.5 million. So 8,497,458.20, according to Karen's calculations. So that's in place, and actually had gone back and got a little bit more money, which is in that number. So then the commissioners had previously authorized I don't know what you'd call it, a match or up to a contribution up to 3.2 million. Where we're at right now with the design, and I've talked a lot with Roadhouse, Dossie has as well. We've had weekly meetings almost with them and the design team. And what we'd like to do is request that the commissioners approve an amendment to the construction manager at risk contract for a guaranteed maximum price that will not exceed $11,650,000. Now, that number, and with the chair to sign, because we're going to be down to the wire with the chair and Roadhouse Construction. But with that said, so what's in that 11.65 million number? There's 15% contingency, which is higher than we normally would have. And that's just because we're not 100% done with the plans. And then there's also all the furniture, some of the side stuff, some of the multimedia things. So there's some padding in that number. So we'll continue to work to get well under that, hopefully. And I think Roadhouse is doing a good job and working with us to get to that point, and our design team as well. But anyway, that's we're wanting, I guess, to have the commissioners consider approving that as a ceiling for the guaranteed maximum price. And then if there's any changes to that down the road, we'll certainly come back, and we're going to do our best to be nowhere or be well below that. But I think that's the highlights. And if you have questions, let me know.
Just a little bit of an amendment, Brian, on your number. It didn't include the newest money, that 889. So actually the total from the Wyoming Library System is 9,386,911.
Oh, I probably read her email wrong. I'm sorry.
Yep. She has the very total in there.
Okay.
So anyway, that's a little better look. But that's what we have available. So we do have the funding available to do the project.
Oh, she's right, 9,386,000. Yep, I missed that.
Madam Chair, but the request is still the same, 11.65.
Yes.
And I'll also add, Madam Chair, that that's basically everything except the professional services. So all the architect, the engineers, HVAC, mechanical, any of that, geotech, which there's been quite a little bit of everything so far. But all that's not in that number.
Any other questions for Brian, or what's the pleasure of the board?
Madam Chair, I would move to accept Ryan's recommendations. And allow Madam Chair to sign.
Second.
I have a motion and a second to approve the recommendation of a guaranteed maximum price that would be under 11,650,000 and allow the chair to sign the firm before October 1st. Any other discussion on the motion? Hearing none, all those in favor?
Aye.
Opposed? Okay, motion passes.
Thanks,
Thank you.
everybody.
Thank
Thank
you.
Brian. That 3 million quickly changed, didn't it? The original. It was 3 million.
Come on.
Yep. That's the beginning. I know it's the very beginning.
Oh, yeah. Thank you.
Plus.
Okay, the next thing on our agenda, Sheriff Darrell Stewart with, opening some vehicle bids.
Thank you, Madam Chair and Commissioners. We have 4 bids, it looks like at this point, from 4 different dealerships here in Park County. This first one will be from Jenny Menhold. Look, we had a total of $190,280. Then with the trade-ins of 48,000, less that trade-in would be $142,280. That would be for 4 new Chevy Silverado 1500 4x4 crew cab trucks.
Madam Chair, how many vehicles are we looking at here?
4.
Four.
The next bid is unlabeled at this point. This will be from Yellowstone Motors for 4 2025 Chevy Silverado 1500 LTs. Shows a total price of $231,200, less the trade-in of $57,000. Don't have the total from that. And no net price listed off that I can see. Get back to them. I can figure it out. 174. Thank you.
200.
Next bid is also unlabeled at this point. This one will be from Fremont Motors in Powell for 2025 Ford F-150s, showing a total price of $207,540 for 4 trucks, less the trade-in of $60,000 for $147,540. The final one will be from Fremont Motors here in Cody. For 4 2025 Ram 1500 trucks. For a total of $191,428, less the trade of $64,000 for a net price of $127,428. You bet, for the net price of $127,428.
So I believe you would like to review those bids and make sure
Yes.
they meet your specifications.
Yes, if I can take
Did
that under,
you want to come back this afternoon or do you want to wait 2 weeks?
I can sure come back this afternoon.
We have a 1:30, so if you'd like to come back about 1:45,
135. Yes, Madam Chair, do that.
thank you.
Thank you.
Perfect.
Okay. Thank you. Well, they just tell him we're open. We can
Order though for this. Thank you for letting me come and visit with you guys.
Yeah, sure.
But it's Travis Mulder, Rural Irrigation.
So Travis is looking for a letter of support, which is the next thing on our agenda. Go ahead and get started. Thank you.
All right, thank you for meeting with me. I figured I'd better meet with you. Thank you for meeting with me. I got a cold, so anyway, Willwood Irrigation is finishing up a level 2 feasibility study with Wyoming Water Development Commission, or office out of Cheyenne. And we have a project that was failing before the study. So I wanted to come talk to you guys about getting a letter of support. We put a application in for level 3 construction fund. This project's called Willwood Chute. It's about 460 feet long. It's a 3-sided concrete chute. We're looking at putting it in pipe. It's failing pretty badly. The last few years, we've had more seepage coming out in areas other than the structure itself. So we submitted an application last month. It was due by September 1st for the funds with Wyoming Water Development. And we've worked with NRCS and received 900,000 through their EQIP program. Wyoming Water wants 50-50 cost share on this project, so. Anyway. The total project cost is almost $1.7 million. And I just wanted to come to you guys and see if I could get a letter of support to go with that application. I don't have a copy or anything rough stuff, but
You could provide one if we. Okay. Questions, thoughts? So we're talking about a level 3 WWDC.
Yep.
1.7 million total, and you have 900,000 of that from the conservation. So you have matching funds.
Yeah.
Madam Chair, I make a motion that we provide a letter of support to Willwood Irrigation for their application to the WWDC.
Second.
And I talked to my project manager and he gave me the person's name that we need to write the letter to. I can at least leave that and then get a letter made up.
Madam Chair, how, and what was the deadline before you needed it?
Oh. I figure I could, if we can get it like your next meeting, first part of October.
How many needs to really know?
It's in the motion to allow the church sign or if not.
We've agreed to provide a letter of support. We've already taken action. We don't have to do anything. We don't have, if we vote on it, if we do a vote on it, we don't have to do anything more. It could be,
We can take care of
it
it.
could be stamped or,
I'll get that to you by the end of the week.
So I have a motion to do the letter of support for Willwood Irrigation. Any further discussion on that motion? Hearing none, all those in favor?
Aye.
Anyone opposed? Okay, yeah, if you work with Molly and get us a draft.
Okay.
Okay.
Thank you all.
Thank
Good
you.
day.
Good luck with the project.
Yes.
She said that.
as the form. As the form.
Okay.
Pretty sad.
Yes, please. Let's wait a few minutes.
Depends on how you do it, because there's a certain price, lower price if you pay right now, or there's a different, higher price if you can, if you want to be able to change it.
It helps hard to find. Yeah, guess we'll go ahead with the next thing on our agenda. Bentley appeal, and you all might remember that this is an appeal that we heard about 2 weeks ago. And it had to do with some additional construction and a commercial sign on a lot in the Clark area. Where, the permit applications were denied, basically due to some deed restrictions that talk about commercial use in that subdivision. So we need to have a discussion on what we're gonna do here, what our answer will be to Mr. Bentley's appeal.
Madam Chair, my main question to Todd is, you, earlier when you came, at the other meeting, you referenced a case law. Do you have that still? And what was that in specific?
Todd, excuse me, Todd Bentley. It's
Todd.
I think what I was referencing was the Supreme Court trying to come to a conclusion as to what covenants, how long are they valid for?
Right.
Yeah, and they'd come up with that was Coke versus Gray. Coke versus Gray.
Coke is C.
I'm sorry, that was KOCH. And that was April 19th of this year.
Versus Gray. Is that what you-
Yes.
I'm sorry, I don't remember.
And it was based on the first of breach. It's like any other, covenants like any other contract. And they were having the same difficulty,
Understand.
obviously. And well, who breached, and since they failed to keep a board, yeah, there's subdivision lines drawn, that's on paper, and that's all legitimate, but
So the way you interpreted that was that because they did not keep a homeowners association or group active, that those were not viable.
yes.
Did it have any time limit or anything like
I
that
just looked it
mentioned?
up. It's
No.
all got it out there.
If you have it, can you kind of read it?
Well, I mean, no,
Okay,
let me
just
see if
really-
I can get, it's pretty long.
Usually they have some kind of.
Yeah, I'm
conclusion.
trying to pull down to it. Conclusion, the first breach doctrine of contract law does not apply to Ms. Coke's claim that Ms. Gray breached the restricted covenants. Yeah,
That doesn't,
that doesn't tell me. You'd have to read the whole thing.
Madam Chair, in my opinion, and I apologize to Mr. Bentley here, but as much as I really would like to make a decision today, I want to make the right one because this is a very sensitive issue moving forward, kind of sets a precedence, and I believe, quite frankly, you know, two wrongs don't make it right, and because you were allowed to have this business and it wasn't brought up, we didn't know, or the past commissioners possibly at the planning and zoning were aware of the covenants. You have an extreme situation where you are somewhat separated, and I get all of that, but it still doesn't change what our rules are. So I believe I want to help you as much as we can. I think everybody does. And if we can find a, for a better term, a loophole here that this covenants are no longer in effect, I don't see any reason not to grant your appeal. But until then, I'd like our county attorney to research this case and see if it is indeed relevant to yours and whether it can be determined. And I believe it can by us if based on his opinion that it is relevant to this subdivision, which I am in agreement. I mean, it was put together in 1977 by, and I think I mentioned, I know the history here, you will too, with Fast Eddie Ricketts. So, I mean, there was probably some questions in the covenants, all how it was written to begin with. So I would like to have our county attorney research this case law, and if it doesn't to indeed have an effect on this decision, I don't want to make the wrong one today.
So are you making a motion to delay decision on this until our next meeting, or what do you want to do?
I guess I'm asking Mr. Bentley, do you want a decision today? Or would you?
Is it possible? I've been reading through the county regulations. Is there a regulation that says that we've got to follow covenants?
I do have the language here, I think, in the staff report. Commissioner?
Madam Chair, I think getting back,
Mike,
I think, yeah, we disregard. I don't want to be in the executive session, so.
Yes, ma'am.
I can't hear.
I'm sorry, I'll speak up. So Joy Hill, planning director, I did find a recent case regarding this subdivision. In 2022, the district court, concluded that the owner of lot 41, which actually is a park space in the subdivision, it was determined that they shall not construct any structures because of the park space, particular lot, but also shall not engage in commercial use. I did not have the time to do the case. I just was given this information. So if the county attorney is going to review other case law, and I would also refer to this case, which is recent within the subdivision, Acton versus CJ Smith Land Services, also the Rickett and Little Rock Well Company. Because it is possible that the covenants were addressed as part of this case, eventually I just don't have enough information about the case to know. But the fact that there was no commercial use, I wonder if that would be that work. It was particular to the declaration that this subdivision was intended for recreational use. In particular, the plat itself says it's Corner Circle 4RV recreational subdivision. And so I guess I would like to have the opportunity to do that to see if covenants will come down discussion as well.
Chair, Joy, did they mention by name of who the homeowners association was? Did they have a committee of any kind? Yeah. Because as part of the first one, on the Little Rock Land Development Corporation, which is no longer viable, they listed an architectural committee that they had, which was a 3-person board. And that has to go through approval through that 3-person board is there still a three-person board? And that's subdivision.
But I do know that rural rock land development, is a part to this 2022 case. So I don't know.
Madam Chair. I don't have no objection to researching this recent case, although I have some knowledge of it. I know it was settled out of court. It never made it to a full decision. Cause I am aware of that issue, that recent one. Cause the case never finished. It was settled.
Do you have the language from our regulations? I know we had it and I can't find it this quick. Thank you. Because Mr. Bentley asked that question, I'd like to answer that for him. I'm sorry, I thought I had it here and I can't find it real quick.
I guess without objection, Madam Chair, I'm with, unless Mr. Bentley really wants a final decision today, which I'm afraid he may not get the one he wants. You may want to, I would prefer to research this further.
Understood.
I'm not sure that's been required.
Okay. We'll close the public hearing, so we should,
It's not a-
but I don't want to put him off forever.
I know.
Madam Chair, I'm reading from chapter 1, section 11 of the 2015 regulations. A, under 11, says no county obligation. Persons owning property in an unincorporated area of Park County may have a covenant or against their property that affects how the land is being developed. Such covenants constitute a private party agreement between the property owner and the covenant and subsequent owners. The county does not have the power or obligation to interpret or enforce such covenants. If there is a simultaneous violation of the covenants and county regulations, the county considers covenants as relevant events and may choose not to enforce the regulations until the covenants have been enforced. If the county requires particular covenants or is otherwise a party to a covenant, then the county has the authority to enforce the provisions of such covenants. So, Madam Chair, I don't feel like enforcing the covenants. Enforcement would be, we already put something in there against the covenants, and then I would do that. I am simply not ignoring the covenant. Let me give you a for instance.
If you want to come up to the mic, because I'm not sure about the recording. Thank you.
So let me give you a for instance where this could be rather difficult. We have a subdivision in Park County, Schneider subdivision. We had a lot owner who requested to subdivide a lot in that subdivision. But the covenants clearly stated no further subdivision of lots. I think in that particular case below 5 acres. In this particular case, the subdivision would have created 2 lots under 5 acres. So if we had ignored the covenant, that individual would have gone forth to split their land very clearly in violation of those covenants. In my opinion, similar to this situation where the county is aware and it's clear statement, there's really no interpretation required. It's clear, no commercial, no sign for advertising. I don't feel like there's any room for question. To me, it's not right for me to say to all the other owners in that subdivision, I'm ignoring your covenant. I'm going to go forward and have the county potentially issue a permit for this thing that is clearly in opposition to what you all want for your subdivision. So this is a struggle that we have. I have numerous requests on my desk right now for people who want to do something. It's in opposition to their covenants, and I've told them no, with the understanding that there's about to be a decision made on this type of a matter that could change that decision. So, you know, this happens frequently. It's not an infrequent situation. And so I just would like to say that, you know, it's not just about the commercial in this particular case. It's about no future subdivision in another particular case, or, you know, no something else in another particular case. Take, for instance, we had a recent 35-foot tower that was going to be placed on a county property in a platted subdivision where the covenants expressly stated that the only things to be placed on those properties were residences. And so we did not end up allowing a particular tower to proceed because of those covenants. In that particular case, we were a party to the agreement because we owned the land, but I would argue it's a very similar situation. I think it is difficult. I understand the frustration. I in particular understand the frustration when other people you know, well, someone else has already violated the covenants. Well, I mean, that's not my responsibility. I can't, you know, but what I can do is prevent someone from making it worse. And if it truly is not a problem to the people in that subdivision, then go get the covenants changed. You know, but it's time to talk and like get that. So that's my opinion on that.
Thank you. Commissioners, where do you want to go?
Madam Chair, my issue is if there's no architectural committee in that area, and that's part of the agreement that was in these covenants, the homeowners association is already violating their own covenants, right? If they don't have an architectural committee. Yeah, so, you know, is it okay for them to violate their own covenants because they're the homeowners association? And does that make their covenants null and void if they don't have an architectural committee? So there's our attorney.
So Madam Chair, that's where, unfortunately, yours, if it stood alone, to me would be a slam dunk. But we have multiple others, you know, waiting in the wings that this could impact, and it could be a lot different outcome. You've probably got neighbors that don't give anything, they're fine with it. But the next one down the line, we might have neighbors 10 deep that have pitchforks and torches against what they're proposing. And if we make our decision on yours, how do we make a different decision on one coming up? That's where we're at. And I agree with Commissioner Teal. I would like to, and I'm reading through Coke versus Gray, and some of it I think is applicable. Some of it might not be applicable, but I'm just glancing through it right now. So, I mean, if you want a decision today, I don't think you want our decision today. It's where I'm coming from. I would like to have a little further review of some case law to see where we stand, because Commissioner Mangold brings up something. Are they in existence? Because they no longer have, but does one part of them not being in existence mean the entire document is null and void? A question I can't answer.
So Bentley, are you okay waiting a little bit longer for this?
Judging by everybody's looks.
You better be.
Okay. Part of my frustration here is that, I mean, I'm just trying to do the right thing. I thought I was, and you know, I started this in April, now we're in September. I'm busy chasing out around the hills, and building season is coming and going pretty quick here. My frustration is that I think the county needs to, and I know you're working on new policy and whatnot, but this needs to be moved around. I stopped because I had been trying to put together a letter of approval, disapproval from my neighbors, the quarter-mile thing. And in fact, I got behind on that and didn't get it done. But I stopped and talked to a guy this morning, and he's putting up a 30 by 60. And I said, you got your permit for that? I'm not going to say what he said. But the point, I said, well, why not? Because of this. It's so cumbersome. Why bother? Instead of getting every building permitted, I mean, which I'm trying to do, you run into this wall. And so am I willing to wait? Yeah, because I think it's important that policy be reviewed.
Appreciate that.
You know, for everybody else down the road, whether mine passes or not, but.
We appreciate you giving us the time to hopefully get this figured out, and appreciate you doing it right in the first place by asking for the permits. So we understand the frustration in some aspects, but I don't know, we have October 1 as a meeting day possible. After that, it would be October first, then look at October first, that gives us 2 more weeks.
Depends on what
Yeah.
Brian
legal,
says.
Yeah,
Madam Chair, I'm not sure that we need to establish that right now. We can notify Mr. Bentley.
we can shoot for that date and we'll find out how much time legal needs. They're a little shorthanded right now too, so let's see what we can do, but hopefully in October, we can get you an answer.
Madam Chair, I don't recall, was the public hearing closed?
Yes.
Okay, thank you. I just wanted to confirm.
Okay, so thank you for your patience and we'll get back to you.
Thanks. You're chasing elk, you don't have any time to work on guns anyway, so what the hell?
Okay, lunch till 1:15. Sure.
Made a scrub before, don't sand that. Yeah, scrub it all.
So they don't.
They kick.
Cool. Okay, I think we're close enough to 1:15 that we can reconvene here. The first thing on our agenda, Pioneer Place subdivision preliminary plat review. As you all might remember, we had this on the agenda a couple weeks ago, and we determined that we needed a little bit more information. Or at least two things. One was a request about the easement that exists, and the other was the discussion on the fencing statute that is not a very good statute that we're having trouble dealing with. So that's the best I can say about it. It's not very good. So, we're at a point where we have a proposed 8-lot subdivision. This is a preliminary plat review. Is there any other questions or thoughts from commissioners, about moving this forward, or what kind of concerns we might have?
Madam Chair, after visiting with council, I think we can move forward with it. The easement is not it's nothing we need to, well, it's not in our purview. We don't need to deal with it. The fencing issue, again, the statute it's tough. And I think, you know, if they fence the 3 sides, you've got that ditch there. I mean, if we can't fence down the middle of the ditch, I think to move forward with what they proposed. And with that, I'll make a motion to approve. Second.
Have a motion to approve, excuse me, the preliminary plat on Pioneer Place subdivision as presented. Any further discussion? Yes, Commissioner.
And I in almost full agreement with you, however.
Almost full.
In looking at, I believe it's the east boundary that you're referencing that would not require a fence. Or do you want a fence built on the setback?
Well, I guess we have the developer here,
It's the west boundary along it.
west boundary. It'd be that
That's
west
west?
boundary east of the west boundary east of that. Is that what you're talking about? Are you talking about? You say we should require the fence to be built back.
Just ask outside the whatever easements, irrigation district that buildings have on that end. This is not gonna be good.
You got any comments on that?
At all.
I don't see how you can build one without impeding the easement. Unless you're gonna be way back into the. Yeah. So no one motion stands.
So we're considering the drain as a natural boundary for, doesn't require a fence.
Kind of what we're looking at, because we have no other direction, and it makes sense.
So they,
Yeah, Madam Chair, I mean, can something get in there? Yes, they can. But how far are we taking this? I mean, if you've got cattle running down the county road, you've got bigger issues than them getting subdivision.
Okay, any further discussion on the motion to approve the preliminary plat for Pioneer Place? Commissioner?
Madam Chair, you're still gonna fence, like you talked to the ditch, you're gonna have gates, irrigation district. Fencing east and west.
North and south side.
Yeah, yeah. Have the gates where they can access. Yeah, where necessary. Have it from the north side of that.
I would say that would be required simply because all you can have on the other side of the gate and post.
Well, I think the inside, that's for the irrigation. Access to the fence.
But you get into that, out, just have the edge of the easement. In here.
Can you use the mic, please?
Use the mics. Yeah, I'm good.
I think, I'm trying to get my directions. Just this is north,
No.
West.
Up is north.
west. So the west side of the fences could end at the easement, and it wouldn't, this ditch would not be completely open. There's no need for a gate.
Well, I thought you were talking earlier about when the fence lights come down, take it to the ditch.
Right.
And then have a gate to take the
Top of the-
access. Maybe I misunderstood that.
Oh, that's fine. I'm fine with that. I just.
Right. Right.
Okay.
Okay. Okay. Had a call for the question. So all those in favor of the motion to approve the preliminary plat for Pioneer Place subdivision as presented? Say aye.
Aye.
Anyone opposed? Okay. Motion passes. Okay. Thank you.
Madam Chair, resolution.
Thank you. We could. Daryl, do you want to go now? We've got a few minutes before the 1:30 and I don't think our client is here.
Yeah, security.
Crowd control.
We weren't gonna mention that part.
Madam Chair, I appreciate the time and love to look at these bids. There were some differences there, and I did have contact both dealerships and Fremont. Root Miller and bidding that whole, again, we're down to $14,850 difference between two of those bids, Fremont being that bid. I had some concerns. They had a bench listed in there. I did confirm that they had 40/20 split. There was a little bit of difference in the motor spec. One was a 3 liter, we spec 5, but with the current horsepower, the cruise ability on that 43 fine those. The warranties were a little different. Mr. Miller brought to the attention that it was a 5-year warranty, 100,000 on the overall warranty, whereas the other one is 5 years, 60,000. But in light of the current bill I just received on the aircraft issue, it's probably best to go with the cheaper of the two.
Okay. and
That
so
would be my
And
recommendation.
that is approved.
That is,
Co-
I'm sorry, Fremont Cody.
Okay.
With the Dodge pickups.
So we have a recommendation from the sheriff, after the 4 bids have been reviewed, to go with, Fremont County, which is 4 2025 Ram 1500s
Correct.
in the amount of, after trade-in, a total of $127,428.
That's correct.
So move, Madam Chair.
Second.
Motion and a second to approve those, that bid. Any further discussion on the motion? Hearing none, all those in favor?
Aye.
Anyone opposed? Motion passes. Thank you.
Thank you.
Thank you. Okay, we have everybody, Cody? Okay. Next thing on our agenda is Huger permission to proceed with a septic system in simple subdivision number 11. This is an interesting one that had to do with an appeal of a planning and zoning decision due to some plating conditions with the city of Powell. Do we need any more information? Do you want any more information than what we've received on this so far? Right. Okay. We do have a letter from the city of Powell, from the mayor, that does state that the city of Powell would allow a septic system in this instant. It does say that if and when lot 1A becomes annexed into the city of Powell, all city services will be required along with the abandonment of the septic system. So that would be up to the landowner to understand that if we were to approve a septic system, it could be a long-term situation, it could be a temporary situation. I just don't know what that annexation might look like.
Madam Chair. I just want to clarify that this letter and or a resolution that will be recorded in case for some reason this land is ever sold or split or done something else, that this same letter would be a recorded document, not just some decision here that. So if we approve the permission to proceed, will this be done by resolution? Or
My
how do-
understanding is it would be,
Yes,
yes.
okay.
Yep.
And the resolution, okay, thank you.
So the resolution should be clear that we received information
Okay.
from the city of Powell.
Madam Chair, before we go any further, Mr.
Yep.
Krueger, you were, obviously Commissioner Livingston, you recall calling me and visiting with me? Do you recall, saying that our planning and zoning director threatened you with penalties and jail time? She did. She threatened you directly. That's interesting. That's not what I've heard. On the phone, she threatened you with penalties and jail time. Or was it in person?
So,
Were you personally threatened by our planning and zoning director? No, Mr. Brewer, that's not what you led me to believe, and that I do not take kindly to being lied to or someone trying to manipulate me. That is a very serious allegation. And that's not how we do business here. I do not, if I would, and Mr. Watts, you're here. Were you personally threatened with penalties and jail time? And can you recall the conversation from?
Conversation was what I see. I have come to the meeting. Asking like it, the variance. Well, what if I just go ahead and put it in? People worry about it. But we did it. He didn't want to do the land. She said, well, I thought the land storage. If you put any wastewater in, that's like a thing. I signed.
She can't. Was that a threat? It was a statement of facts.
Also, if you do that, then you won't be on my list of preferred contractors. Now that item, you cannot have.
I don't see where statement of the facts is the same as a threat.
Yes, ma'am. Yes.
Madam Chair, Commissioners, I did speak with Mr. Watts. My staff was present for that conversation, and my staff would be happy to obviously testify as to what was said. So Mr. Watts came to the office and he claimed that he was going to put a septic system on Mr. Booger's property. And he said he was going to do it without a permit. He asked if he can get an as-built, and I said no. And the reason I said no was for the same reason that I can't issue a permit in the first place, is because of the condition on the plat. So part of that conversation was, well, what's the worst that can happen if I just go ahead and do it, since you're not going to give me an as-built? Well, the worst that can happen is that the county attorney, should he choose, can put on his state hat and go for criminal penalties, which is what I told him. I did not speak with Mr. Sporik. I didn't tell him I spoke with Mr. Sporik. I just told him that that could happen. I also said it's very unlikely that that would be an approach the county would take, because we want to rectify the matter. We truly just want to get this remedied. We want to get your answer to getting a septic system on the property or not. And that's why we're here today. So ultimately, and none of the history has been mentioned on the record, but just for the record, there is a subdivision plat. The original plat stated that lots 1 and 2 of this subdivision cannot have a septic system. They have to connect to city sewer. I believe the reason for that is that this particular subdivision at the time had to be approved by the city of Powell, not just reviewed. At that time, statute required their approval, and they did approve, but it was conditioned upon an annexation agreement, and that annexation agreement binds all of lot 1, the original lot 1, as described in the annexation agreement, and lot 2, to not only annex if it becomes adjacent to the city, but those lots have to act as if they're in the city now. And the property is described, like meets and bounds description. So fast forward, the plat was amended. So lot 1 was changed. And as you know, when we amend a plat, the lot doesn't keep its number that it originally had because it's no longer that thing. So on the plat, the amended plat states that lot 1 was vacated and renamed lot 1-A. Now the condition on the plat, the original condition about the septic still says lot 1 and 2. I have no idea why it says lot 1. Does it say lot 1 because the annexation agreement still says lot 1? Was it an error? Was it meant to be deleted? Was it meant to say 1A? I have no idea. But what I do know is that lot 1 is still on that amended plat as having to connect to city sewer. And in the annexation agreement, lot 1 is described as those original meets and bounds for lot 1. I don't feel that I have the power and authority to overrun that particular condition. And so I told Mr. Booger the best course of action would be to get something from the city. And in final discussion about that, it was determined that it should be the governing body of the city of Powell, which is not Ben Hubbard or Zach Thorington. It is in fact the council with the mayor's approval. And then following that, to come before the board with an amended plat to see if we either need to remove this condition or give an exception to the condition, whatever it might be. Delivered the letter, Mr. Booger wanted to appeal, which he has a right to do. In discussion with you, further discussion about the matter and thought on the matter, I thought ultimately really what I'm looking for is the board's approval to accept this condition. And I gave him a third option to come before you, which is why he is here today, to say, hey, can we just ignore this condition so that I can get my septic system? Because the city, which we believe is the reason for the condition, has given him a letter saying they're okay with a septic system on lot 1-A. So if the board today says, hey, city said it's cool, we don't have any reason to disagree with it, let the guy have a septic system. But please understand, there's more to the story. So Mr. Booger would like to split this property. The letter from the city says a septic system on lot 1-A. Well, if we subdivide, we're not going to have a lot anymore. We're going to have 2 particular properties, which again are still going to be under this annexation agreement by definition of lot 1, meets and bounds description. And are they going to just keep wanting more septic systems on this particular property? And oh, by the way, the people to the west, which used to be part of lot 1, the exempt parcel has grown. They have also indicated a potential interest in subdividing their property. Their property is served by the city sewer because they're right against the road where that line runs at that time. Will the city serve them sewer to a second lot? I have no idea. I guess it depends on where it is and the topography at that point in time. So again, I don't proceed in particular because I have caution in terms of how we're going to deal with the next step of this. But if the board wants to give Mr. Booger the authority to go ahead and install the system because the city has no concern about it, I don't have a concern about that. But I still have a concern that Mr. Booger is bound to this annexation agreement, which any development that he puts on that property is supposed to comply with ordinance as stated in the agreement. Did I read that ordinance? No, I'm not going to. I don't uphold that ordinance, but I have to honor the annexation agreement. So those are just cautions. We brought that forth for the landowner. We brought it forth for the city. Hey, city, did you remember you have these agreements in place? Like, might want to take a look. No harm intended by planning and zoning. We're just here to give people information. So I really don't mind at all if the board grants him the authority to put a septic system on his property at that time. Once I have that resolved, I will proceed with a permit. But until such time, I don't feel comfortable doing so.
Thank you.
Yep.
Just a second, please. I'd like to go one step further with your conversations with our staff. It wasn't even enough that those conversations happened with Commissioner Livingston. Then you and I had a conversation on Thursday morning where I had asked you 2 days before that to contact our administrative assistant and get a time to be on the agenda. Gave you 2 days. I finally called Cody to remind him because we wanted to make this work in some way for you if we possibly can. So I get a phone call from you on Thursday morning. I step out of a meeting, take the call, and you tell me that my assistant refused to give you a time on the agenda. And that is how you worded it. She refused to give you a time on the agenda. Okay, can you tell me what the rest of your conversation was with her?
She said that I couldn't get out.
I can't hear.
Oh,
Just have
can
to come
you-
up and use
can
the
you come
mic.
Up to the mic.
Is that better?
Yeah, you just have to use the
Use
mic
the
because
mic.
he's already
I'm sorry,
recording. They can't hear.
How about now? Okay. She said that I could not get on today's agenda and that I would have to wait basically till next month to get into a meeting. And she said that she had to call and check with Joy Hill before she could issue me a time.
You think she clearly said she couldn't get you on today's agenda?
Yes, ma'am.
Robert, I believe that is not the conversation that you said you had with him. You indicated that you would get a time for him, but you needed to visit with Ms. Hill in order to find out how much time should be allotted for this situation.
That's correct, and if we were expecting it due to the appeal or not, if this was a separate, not if this was a company. And I told him I called back within 10 minutes and I found the phone that was built. And he called me right after.
I don't think there was a refusal to give you a time or to work with you. And to indicate that our staff is not trying to work with you and they bend over backwards a lot of times to work with the public, it's pretty disheartening to hear that you think that she was telling you that it wasn't gonna happen. So I'd appreciate it if you use a little more thought process to what the conversations actually are and pay attention to what she's saying, that she would get back to you. Okay, thank you. It's a pleasure, the board.
Madam Chair, I
Oh, Cody, come on up. You come to the mic, please.
Madam Chair, Cody Schatz with Engineering Associates. I don't know if you guys ever see when we do subdivisions and everything else when we're around a mile from City of Powell. The City of Powell requires these annexation agreements that Joy's been talking about on every subdivision. So every subdivision that I've done, they require an annex agreement. And in that annex agreement in the bottom, and the reason why they do that is if they're within a mile of the city, it says that the owner agrees that all the property within the area of the proposed simple subdivision or major, because I've done it on major subdivisions before, will be voluntarily annexed to the city upon demand by the city when it becomes contiguous to the corporate limits of the city and when the improvements required by the city shall further be installed at the expense of the owner. It goes on. And so they do that each time because they know if they're within a mile of the city, that sometime the city will grow out there. So these annex agreements are always out there. For some reason, this one's holding this project up because of that annex agreement, but I know Lone Pheasant, all those other ones, they have that and they all have septic systems. And they all know that if the city of Powell grows out to that point, that they're gonna have to get onto city utilities. So I want to make sure that that point is clear on those annex agreements. And that is the reason why. And I know I don't want to hash out some more stuff because it looks like we're going down a whole bunch of different roads, but that is where the legal is at. That legal is in that one, and the legal for the extension of municipal sewer services, that's the two legals for that lot one. But the plat clearly states that lot one was vacated and it is now lot 1A. Just because a surveyor put some text on there that says you still have to hook up to lot one does not mean that it needs to be an amended plat.
The
It's-
annexation agreement clearly has a meets and bounds that
It does.
describes that property. So we're not referring to it as lot one or 1A in the meets and bounds. It refers to it by a description of the
Correct.
parcel.
But how, as me being a professional land surveyor, how can I amend the plat to fix that agreement? It's not on the plat, it's in an agreement. And so then when you get from going from the Powell Planning and Zoning to the Powell Council voting to approve that they don't have to hook up to a sewer, now you have that letter, just because it doesn't state each of those items in there, their attorney reviewed it too with all the information, and that's the letter we got from the City of Powell Council.
understand. I'm just wondering why there couldn't be a statement on the plat that does not refer to lots by numbers and just said this subdivision is under an annexation agreement with the city of Powell.
Then they all need to say that.
That's fine, but in my understanding now, and I guess this is just a current thing, but I know this happened years ago because I dealt with it with water district, but currently, my understanding is the cities can review and give options, but does the city of Powell still do those currently?
Yes.
Okay.
Case on Estates did it, the Lone Pheasant, I'm pretty sure did it. I'm pretty sure that these are all within that mile that they have to have this annex because the city of Powell wants to have the power that if they're growing out there, that they can take over the
Right, but
subdivision.
statutes changed about what the county was required to get from the cities. So that's what I'm wondering, if the statute didn't make it so that the city of Powell doesn't necessarily have that power to do that anymore. I don't think they do. But anyway,
Yeah.
we can check on
I
that.
know the last subdivision that we did last year with them, they had the same annex agreement, right? You had to sign an annex agreement with the city of Powell last year. In his last
Well, they may want
subdivision.
to, it's just whether they have to. or not. Okay. So I guess just to clarify one other thing, if we're doing two things here, one is the septic system and then talked about a building permit, correct? Okay. So this is just in my mind, so I don't know if it's right or not. That's why I'm asking. We issue a building permit. The way that annexation agreement reads, you would have to follow the ordinances of the city of Powell in order to build. Am I understanding that right? Right, right. That's, I guess that's just what I was gonna say. If we're not positive about that, you might want to check with the city of Powell before you build it. If you're allowed to have the building permit. Okay. Okay. Pleasure of the board.
Madam Chair. I have, due to the letter from the city, I'm, eventually make a motion to approve. But my question first with staff is, and it does bother me, because I want to ask you, Joy, do you have a list of preferred contractors?
You don't have a list, but maybe have people that can contact them. But I did mention that in the future, that is the direction I'm talking about going. And I also mentioned to Watch that it would not be good if you could put it in the ground and the violation is issued. It's mainly part of that violation.
That's fine. I somewhat agree. We do not need to get into that of having a preferred list. That's not. I'm sorry, but I somewhat agree with that. That's absolutely wrong.
I'm sorry, the potential for having contractors somehow registered or something in the county, we're not there yet, but that's a discussion. But that would not that.
I know there's a lot of debate on which way direction we may go with that. However, I just want to question, if you have this, if you are, in my opinion, please stop. Okay. With that, Madam Chair, I move to approve permission or a grant as appeal to put in a septic system and or proceed with the building permit. Correct language?
So
I think so, yeah.
He's gonna die for no second.
No, I'll second. I didn't know if you had more questions.
a motion and a second before the board to approve the appeal to install, to be allowed. Oh, that's true. He did send in, well, that's another statement. Okay, move to approve to allow Mr. Ruger to install a septic system and receive a building permit from Park County. That work?
Madam Chair, question. We have the permit issued yet? So you're saying to go ahead and issue the permit to install?
Right.
Okay.
Permit for a septic system and a building.
Okay.
Okay. Any further discussion on the motion? Hearing none, all those in favor?
Aye.
Anyone opposed? Motion passes.
Thank you, Madam Chair. And like the email stated that if he got approved for this septic thing, then he would withdraw his refill for the, so do I need to do that? It was in writing. Do I need to
Mr.
redo
Do
that?
it in writing.
In writing again? Okay,
Withdraw your appeal.
we
Okay,
can get that.
thank you. Okay, thank you.
Thank
Thank
you.
you.
See, Cody.
Move to adjourn, Madam Chair.
Second, Scotland, Jerry.
Been moved and seconded to adjourn. Any further on those two? Any further
No, it's
discussion? Hearing none, all those in favor?
Aye.
Aye.
Anyone opposed?
I hope to adjourn right there.
Okay.